All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, Phil, I got a question for you, and Jeff, feel free to chime in as well, but I'm really directing this one mainly at Phil. What
Don't
does
throw me more
fishing?
trivia. Are you throwing more trivia at me already?
I am. You know, I love to do this to you. I love to catch you flat-footed, Phil.
I'm not
What
good at trivia.
what does fishing, and in particular herring, the fish, a herring, have to do with every single workplace in America?
A red herring?
Nope,
No,
just herring.
just a herring. Oh,
Yep.
geez. I have no idea.
All right.
No idea. Jeff, do you have any idea what he's talking about?
Maybe I might be completely off on this, but in Seattle they throw fish.
Yeah.
And it
Yeah,
is
down at the market. Yeah.
Yeah, they throw fish in the market, but it actually set up a way in which to run workplaces called fish. There's a fish philosophy. And in the fish philosophy, the four metrics are be there, play, make their day, and choose your attitude. And that's how they incorporate to create a better and more psychologically safe workplace. I may be off, but that's what I'm guessing. Fish philosophy.
All right,
Okay.
you're just so Phil. The lifeline worked for you the first time, but not the second time.
Not this time. Oh, way off.
Hey, Jeff, welcome to the program. This is what lawyers do. All right. And I've worked with a lot of lawyers. What they like to do is they want to ask really, obscure questions that no one, of course, is going to know the answer. And then they want to use big words that they have to explain to you.
Like malarkey.
These types of things. Yeah,
And
like
baloney.
malarkey and baloney. This is traditional weekly stuff for me, Nick, or Jeff. But all right, Burt, let's hear what's herring have to do with every workplace?
Jeff's out there playing five-dimensional chess on me. Mine's much simpler than this. So I've mentioned this on the show before. The Supreme Court, the U.S. Supreme Court, had taken up a case some months ago that's likely to have a huge impact on all workplaces across America. The court, in this case, has questioned a very long-standing, a 40-year-old legal doctrine that gives federal agencies, you think about the Department of Labor, the National Labor Relations Board, the EEOC, those federal agencies have had a very, very wide berth to interpret unclear laws as administrative agencies. And the U.S. Supreme Court has heard two appeals that would rein in or constrain these administrative agencies in their activities. Specifically, the court is considering overturning the 1984 ruling in a case called Chevron, that's the oil company, that requires judges to defer to the administrative agencies when those administrative agencies offer a quote unquote reasonable interpretation of a statute. The Democratic administrations in the U.S. government have relied heavily on that ruling, use it to justify mandates on energy, the environment, and the workplace. The court heard 3.5 hours of argument on this case, and it's unclear right now whether they have the votes to overturn the ruling, to overturn Chevron, but the conservative majority really did signal some skepticism toward it. For example, Judge Kavanaugh said the Chevron doctrine had fostered legal instability, and I think this is something that we've seen in the workplace, and we've talked about on this program many times. Judge Kavanaugh specifically stated Chevron itself ushers in shocks to the system every 4 or 8 years when a new administration comes in, whether it's communications law or securities law or competition law or environmental law. It's just a massive change that is at war with reliance. And his point is that if employers and other industries that are regulated by these administrative agencies could rely on court decisions, which take longer to evolve rather than the decisions or the policies of an administrative agency that change every 4 or 8 years, depending on who's in the White House, it would bring much more stability to business. That's the argument. So in these couple of cases, a federal appeals court had invoked Chevron and said that a payment by the herring fishermen for somebody from a representative from the environmental department to sit on their boats and observe their fishing activities for quotas. The appeals courts had said that payment was a reasonable interpretation of a 1976 act that governed the management of marine fisheries in federal waters. And the plaintiffs in the case who are seeking to overturn this basically are arguing that Chevron is really a reliance destroying doctrine. If you're a person or a regulated entity, and that's why I say this applies to every workplace in America, because every workplace in America is regulated by the EEOC, the Department of Labor, or the National Labor Relations Board in some way, shape, or form. And if you're trying to figure out what the law is, you should be able to rely on the best interpretation of the law and not have to check for updates every few years, depending on who's in the White House. It's that pendulum we talk about, Phil, in the workplace of, depending on who's in the White House, things swing right or swing left. And so this could be just an absolutely huge decision. I'm not making a prediction right now on which way it's going to come out, because I do think Justice Amy Coney Barrett did express a little bit of favor toward the rule, even though she's one of the court's conservative justices. So it'll be interesting. The court is scheduled to rule by late June, but this could really, really have a huge impact on workplaces across the country.
Wow. Having some stability might be nice, though.
Well, and you and I've talked on the program so many times that, we as employers and management associations like yourself and labor and employment lawyers, on some level, and I don't mean this, per se, but on some level, we almost don't care what the law is, what the administrative agencies say the law is. We just want to know what it is. We don't want it changing every 4 to 8 years. If it's things we don't like, we can deal with it. We just don't want to have to deal with that, and then 4 or 8 years later have to completely go back the other direction because who's in the White House changes. We as employers or business are really looking for that stability.
Absolutely. You said that very well, Burt. You get a star for today, man.
I appreciate it. One other one that I want to mention really quickly, we're going to shift gears, and I had a couple of topics, but I know we want to get to Jeff, so I'm going to just focus on one more. We spoke last week at length about the new Department of Labor's rules for determining classification of independent contractor versus employer. And I'm not going to go through all of the details of it, but there are businesses are kind of up in arms about this. We know that this new rule is really targeting the gig economy, the Ubers, the Lyfts, the DoorDashes of the world, and trying to rein that in and have those folks, the people working for those companies, classified as employees rather than independent contractors. And last week we talked that it's going to be much broader than just the gig economy. Construction companies and staffing agencies are really focused on this. So business groups that are opposed to this new independent contractor rule have taken sort of an unusual procedural move in an effort to get their challenge against the new law heard more quickly. We know that the new regulation, the new final rule is set to go into effect in March, and these business groups that are representing dozens of industries, including the gig economy companies like Uber and DoorDash, instead of filing a new lawsuit against the worker classification rule, they filed just a couple days after the rule on January 11th, they filed a motion in a previous case involving a different Biden administration independent contractor rule that was issued in 2021. While that 2021 rule was blocked by a federal court in 2022, the independent contractor rule released last week is slightly different. They both basically cancel a Trump era standard that put in place a more business-friendly approach for determining whether a worker should be classified as an employee or a contractor under federal wage law. Again, this is squarely on point
This
with what
is
we
this
talked
exactly
about
what you
first.
were referring to with the
Yes.
fish? Yeah, right.
Exactly. So this new rule is really highly consequential for companies that rely on independent contractors, changes how the department determines whether a worker should be classified as an independent contractor. And this new test, that there's 6 factors, we talked about them last week. It's generally expected to make it harder for workers to be considered independent contractors. So again, just to point out that the businesses sort of took this unusual approach. Instead of filing a new lawsuit, they're seeking to have this heard in an old or existing lawsuit in the Fifth Circuit, which is generally considered to be somewhat employer friendly. So that's what I have for you today, Phil. It's that pendulum that swings left to right. And maybe the Supreme Court will weigh in on this, or they will weigh in on this one way or the other, and it'll give us some guidance going forward.
Yeah, good stuff there, Burt. Thank you.
Yep.
From my favorite attorney of all time, from Ogletree Deakins, excuse me.
Phil, that's baloney. Come on.
That's baloney and malarkey. All right. Thank you, Burt. We appreciate that.